He makes a very good income. He has no expenses.
My client is paying her vehicle payment, his vehicle payment, their joint automobile insurances, the family health insurances. He's paid the attorney's fees that this court has ordered to her. He's paid copious amounts of spousal maintenance on a short-term marriage. He is covering treatment expenses, UA expenses, his own attorney's fees, guardian ad litem fees. To suggest that my client has a money tree in the backyard is complete fiction.
Right, Wishart and Wishart 23300174008. My apologies, Miss McLean.
That's okay. Thank you very much. It's the mom doctor appointment day.
Yes, and I understand that, and we'll do our best here.
Thank you.
We are on.
I did sign the child support order and sent that over to Ms. Baldwin. I don't know if that's been sent up to the court for signature now.
We got it. I believe I signed off, but it might just be routing its way.
I have a temporary child support order that doesn't have your signature on it yet, but it sounds like if there's one coming.
There is, yes. So I would just junk that one just in an abundance of caution. The one that's signed by both of us is on its way.
Perfect.
Okay. Thank you.
So, the other thing that we were reviewing today is the GAL report.
Yes.
Correct.
All right. The court have an opportunity to review through, technically, I guess, both of our clients' declarations.
I believe so. Let me, I have a declaration from it was filed on the 26th of October, from the respondent, and
my clients should have been filed on October 23rd.
Sorry, yes, the declaration regarding final GAL review, October 23rd. Yes, I reviewed those.
Okay, great. Who do you want to hear from first?
I have no preference. Either one. Go ahead, Ms. McLean, since you asked.
Okay. So as you can see from my client's declaration, he did have some feedback and input as to some of the factual information that has been presented by Ms. Wishart that was provided in the guardian ad litem's report and recommendation and relied upon to some extent. I would simply note that obviously I think this case was filed in April or so of this year. Starting with the fact that my client had not been allowed contact with Addison for some time. We're now 6 months removed, and my client has been under supervised visitation. He has, at least during those supervised visitations, all of the comments have been positive and glowing about his relationship and involvement with Addison. None of the visitations have had to be terminated by a supervisor. None of the supervisors have had to intervene for Mr. Wishart being inappropriate in any way. And in addition, none of the supervised visitations, none of the supervisors have suggested that Mr. Wishart has been under the influence. As you know, we've been providing ongoing documentation from treatment providers. And while I understand Ms. Wishart has a concern about the continuity of care, obviously, in order to have sufficient care, you need to be able to make full meeting times. And while Mr. Wishart was attending meeting times that somewhat conflicted with his work schedule, he was still there for an hour of an hour and a half meeting on those times when they did interfere with his work schedule. And he made an effort to secure an additional provider to follow through with the treatment recommendations and ensure that he was able to and continues to be able to attend meetings that are managed around his work schedule. We did provide with the court, and I will tell you, to no fault of my client, the tribe has been somewhat challenging as far as getting documentation from, despite repeated requests. I don't know if this is something that maybe they're just not normally used to doing, or if they do them on a less consistent basis. But we did file on October 20th. I had finally received the correspondence from them, as well as proof of the UAs that had been submitted. My client, as I indicated last time we were here, since he's been with the tribe, he's now on the color system. And so they randomly call him, and he's been participating in 2 UAs per week on a random basis. All of those have been negative. It's my understanding that the counselor is going to be providing us updated UAs from this last submission to date. And the hope is that they'll continue to provide those to me so that I can get them filed with the court on a permanent basis or consistent basis. But at this point, he has been progressing well in treatment. And as you had indicated, I think it was during our meeting was the last part of August or maybe first part of September, where he had the one, I guess what I would call a relapse, with him having the shot or 2 of alcohol during his sister's wedding. You had commented at that time, obviously, that relapses are part and parcel and that alcohol is prevalent. And he provided that information to the court. I would also note that he, again, is under continuing UAs, which have been negative. And even from the guardian ad litem's report and recommendation, Addison is struggling. She wants to have more time with her father. She wants to be able to stay in her room. She wants to be able to do more things. You saw from my client's declaration that the end of the visits are a struggle because Addison wants to stay, and mom's now apparently been having to bribe her with candy in order to get her to come without being fussy. Mr. Wishart is supportive of Addison and encouraging her to go home, and that reassuring her that he's going to see her. But obviously, she's wanting some more time with her father because of that strong connection that they've had. He is in treatment. We've provided proof of his NA and AA attendance as well. And we believe that it is appropriate to move this forward. We are asking ultimately that the court provide for unsupervised visitation and transition into overnight visitation that's consistent with his work schedule. He does work a 4-on, 4-off work schedule. Obviously, Addison's not currently in school, and so there isn't anything that would necessarily interfere with her ability of having or exercising visitation during the week overnight, consistent with my client's time off from work. And keep in mind, even when you lift the supervised visitation requirement, my client's living with his folks. He lives with his parents. And his sister and brother-in-law, they all live in the spacious family home. So it's not as if he is going to be isolated with Addison. And that's going to help support her bond that she has with her father. In regards to the guardian ad litem recommendation about this phase issue, you know, I guess if we had somebody who was in the normal, what I consider normal individuals who have significant relapses, and I'm talking about when you have individuals who are on hard drugs and they relapse, that is extremely concerning and significant. You don't have that. You have not had him relapse on anything other than arguably the alcohol during the wedding. And we have provisions and parameters in place to provide for, right, currently you would terminate his visitation for the next week. We unfortunately had to do that once because we weren't able to get the sufficient records to provide to the court at that time from the provider. So what we're asking is that the court not take sort of this draconian, onerous, stepped up visitation plan when we already have a father who has been exercising, I think currently it's 6 hours of visitation, supervised visitation, when again, you have glowing reports from the professional supervisor, from Ms. Wishart's supervisors, and from my client supervisors, and the child who, according to the guardian ad litem, who has a clearly bonded relationship with her father. In regards to services, obviously there's a cost for all of these things. And as it relates to the recommendation that he participate in the 6 months of treatment that was recommended from Ms. Lovely, and that's basically an informational class about domestic violence. First off, I would note again that Ms. Lovely did not find that there was a pattern of behavior exhibited by Mr. Wishart, and that if anything, he is reactive to what was engaging him, and that essentially was Ms. Wishart. Since we've been here, there has not been one incident or set of information that has suggested that he has been controlling, that he has been inappropriate as it relates to the child or during these visitation circumstances. And again, I think that given the costs and all that's involved with this, and the fact that he has not been determined to be domestically violent, that the court not order that. If you do order that, there are, again, my client's got costs affiliated with every time he does a UA, every time he does the treatment with the tribe. And then I think it's $150 a month if he's doing, I think it's 2 classes a month through Olivia's proposed informational class. So I guess our position is that he should not be required to do that. We do agree to the ongoing requirement for sobriety, and he'll continue to follow through with that. We are asking for some holiday visitation time. I mean, obviously the holidays are right around the corner. We've got Thanksgiving in 2 weeks. We've got Christmas in 6 weeks. And he would like to be able to spend some holiday time with his child. We have provided to the court a proposed plan for purposes of moving this forward, and we are asking the court to adopt that and to transition into those unsupervised visits now. So essentially on his 4 days off, we're asking that as they fall within the month, the 1st, 3rd, and 5th sets of 4 days off, from the 1st day off at 4 p.m. to the 3rd day off at 4 p.m. And on the 2nd and the 4th sets of 4 days off that he had, from the 1st day off at 4 p.m. to the 2nd day off at 4 p.m. So that would provide him essentially 1 midweek overnight, and then 3 weekends that are consistent with his days off. If there is a 5th weekend. If there's not a 5th weekend, obviously it'd be essentially 2 weekends, but again, consistent with his days off from work. So that's our request to the court. And we think that it's appropriate in light of what's been happening with the case and Addison's relationship with his father.
Is that, I know that I read that somewhere. Is that, I don't see it in his declaration. Was that?
Don't see what?
The time frame that he's, or the essentially the parenting time that he's requesting laid out. Was it in his declaration, or was it somewhere else?
I'm pretty sure that we have. So if you look at the bottom of page 3, he says on the 1st, 3rd, and 5th sets of my 4 days off each month.
Perfect.
Okay.
That's all. I knew that it was somewhere. I just couldn't find it. Thank you for
okay.
All right.
That's fine.
Ms. Baldwin.
Thank you. So first of all, the court does have the guardian ad litem report. Guardian ad litem spent a lot of time in this case, and there's a lot of detail in her report. And I think that's important. This is not a case where the guardian ad litem sort of just glazed over a couple things, chatted with 2 people, and called it a day. There's a lot of witnesses, a lot of input, and a lot of recommendations that were part of that ultimate recommendation. But there are a lot of concerns. And I think when we look at counsel for Mr. Wishart sort of just glazes over, hey, the last 6 months have been great. No, they haven't. The last 6 months are Mr. denying he has ever used drugs and then getting caught using cocaine. Mr. saying he doesn't have an alcohol problem, but then going to a substance use evaluation with alcohol in his system. It's him within the very recent past failing his sobriety and drinking at a party surrounded by his family, who is supposedly his support system. So the last 6 months have not been, sort of all wonderful. I think that counsel tries to sort of paint this rosy primrose path that everything's fine. That's not how things have gone. And when you look at what's happened over the last 6 months, these have all been problems of Mr. Wishart's making. My client has done nothing wrong. She's, been, hey, this is what the court orders are, trying to be accommodating. But nonetheless, it's Mr. Wishart that has repeatedly sort of not been forthright, not been honest with this court or the guardian ad litem, gets caught, and then says, oh, oopsie, but you should just ignore that because I want what I want and I should just have it. And that really goes into some of his ultimate behaviors. One of the first things we need to talk about is just, again, this denial that he has a problem with substances. It's very concerning that we have the third evaluation and we don't even have a full evaluation from the tribe. I'm fine that the tribe does an evaluation, but if the court recall, he did an initial private evaluation with collateral contacts, where that person said, oh, I have some concerns. If he's positive again or something happens, we need to come back. But he never goes back to that person. Then apparently we have a new one done with Kaiser, and I'm not even sure if collateral contact was given there. And then it's, well, I don't really like that result either. So let me go get one with the tribe that's completely blind to everything that's happened. We have no idea what he disclosed whatsoever. All he provides is sort of the face sheet for the evaluation saying, hey, 3 months, I'm done. I don't have any problems. We don't know if he disclosed the cocaine use, the long-term historical issues with substances, the other substances he's used, the positive tests, talked to the guardian ad litem, didn't talk to my client, none of that. So this, hey, all I got to do is check some boxes with the tribe for 3 months and I'm done. That doesn't match the behavior that we've lived in this case for the last 6 months and really longer than that, really since this case started. So in this case, what we really need to see is a actual evaluation with collateral contacts completed, and then to follow those recommendations. You can't have those evaluations be blind. And that's really what we have now, is Mr. Wishart's just shopping for an evaluation that works for him, and one where by the third time he says, oh, well, now I can just ignore that collateral contact. That's not reasonable. It's not safe. And it's not going to get him the help he needs. He is not going to succeed in treatment unless he gets the treatment he needs. He's only going to get the treatment that he needs if he's honest with the providers. The second issue, guardian ad litem recommends domestic violence treatment, and that's appropriate. What we have here is a young child, a young girl who should not be subjected to his behaviors. These are not just, hey, he's only going to have those behaviors against Ms. Wishart, against his wife. That's not true. When we look at even the statements that his family, just look at what his family told the guardian ad litem. They talked about him having a short fuse. They talked about at points they were afraid to leave him alone. They talked about how he was expressive, and he doesn't really hide his feelings much, and talked about him storming out when he was angry, like bowling over a gate. These are things his family said about him. That's domestic violence. It's, I'm angry, and it doesn't matter how you feel. It only matters how I feel, and I'm going to react explosively. And I think it's very tragic that we have Mr. Wishart engaging in victim blaming. It's her fault I got angry. It's her fault I punched a hole in the wall, which he doesn't deny. It's her fault. I'm just reacting. No, that is not what Ms. Lovely's report says. Ms. Lovely's report basically says that he is immature in his ability to be able to manage his emotions and manage his behavior. And so it then spills out. So the reality is that you can get mad from your wife, from your child, from your sister, from your brother, but that's all domestic violence. And the reality is that Mr. Wishart is not in a place where he even acknowledges he has an issue. And that's, again, where the guardian ad litem talks about that entitlement piece of, hey, I allowed I allowed Kylie to do this. You know, I authorized her to be able to leave the house, kind of things. She doesn't even see that those comments are inappropriate. This is where domestic violence and treatment is appropriate with Ms. Lovely. 6 months of a program is not an informational program. That is you have some things that you need to work on and get well to be a better human and to be a good father to your child. When we talk about costs, it's important to recognize Mr. Wishart lives with his parents. He makes a very good income. He has no expenses. Now is frankly the best time for him to engage in these types of treatments because he has, again, low expenses, essentially no overhead. Every dollar he's bringing in is just cash in his pocket. That's not child support to my client. And my client's spousal support ends, I think, end of December. So he's not even going to be paying that. It's his only obligation is really child support. So now is frankly the time. When we look at that, I think it's important to think about my clients, all of my client supervisors have been very honest and forthright. His fears that they would sort of tank him never came to fruition. But what we do for a parenting plan for a very young child is not based on what that toddler says they like. It's based on our adult understanding of what that child needs and what's appropriate. And so in this case, child is getting to see father, is getting to see father consistently. We want to grow that as Guardian Ad Litem recommends with a stepped plan, but that stepped plan rewards him meeting treatment goals and being able to move forward in a healthy way. These statements that my client has to bribe the child, the client is frustrated. And she's like, I literally brought the kid like a dumb sucker once because I got it at the coffee shop on the way. And suddenly that gets blown up into this huge thing of she's bribing the child, literally a single sucker over 6 months. And again, so there's that frustration of sort of Mr. tries to paint everything in the light most favorable to him. And my client's just trying to give the court sort of the real deal on here's what's happening. But she hasn't thrown him under the bus. She's acknowledged where he's done well, but also said, hey, he's slipped up a whole bunch in the last 6 months. He really needs some help to be a better parent. When you look at that, Mr's still in treatment. He needs to remain in treatment. What we're asking the court to do is to adopt phases 1 and 2 of the Guardian Ad Litem's recommendations for both treatment and for the schedule. I think you should be required to have an updated substance use evaluation with collateral contact with both my client, the Guardian Ad Litem, and copies of all the positive drug and alcohol tests that have happened to date, along with the other evaluations that have happened to date. The court should order the domestic violence treatment. The court should not enter phase 3. That's really a trial decision. We don't know where we're going yet. And it's not reasonable to say that my client's schedule should completely bend to Mr's, that his is the only schedule that matters. And that, hey, because kid isn't in school, mom's schedule should just be thrown out the window. And we put child on one of those awful rotating sort of warehouser type schedules. That's not reasonable nor consistent for child either. So that ultimate schedule should wait. But that doesn't mean that Mr's not getting increases in time. Again, my client says, yeah, adopt phase 1 and phase 2 of Guardian Ad Litem's recommendation. She's not really withholding anything there. She's just saying, yep, let's do it. That is healthy for the child, healthy for everyone. Mr's demands that we just go straight from now to unsupervised visits. Don't make me do treatment. Don't make me acknowledge things that I have to work on. Again, I think that's just a symptom of him being immature in his ability to understand where he's at and what he needs to do. Again, sort of a symptom of that entitlement that the Guardian Ad Litem talks about. It doesn't make sense for the child. It certainly doesn't make sense in a case where we're not that far away from his positive cocaine test. We're not that far away at all from his alcohol that he had this fall after the court said you can't do that anymore. So we're really not that far into this case where Mr's been towing the line. He's really just been repeatedly saying, well, I'm going to keep dipping over onto the wrong side of the fence and just seeing what I can get away with. He really needs to put himself off the fence and fully in compliance and be there for a while before moving forward. And again, that's what Guardian Ad Litem recommends. My client says we should adopt those recommendations. They make sense, but again, wait on phase 3. That's really a trial determination that we should see when we get there and what everybody's schedules look when we get there. That's reasonable. So that's what my client's asking for. I think that's reasonable. and appropriate given the facts of the case.
Miss Kale's here. I don't know if there's anything you want to weigh in on before I loop back around, and I obviously would allow either counsel to ask questions if they have any. If you don't want to, if you want to just stand on your report, that's fine. If you have any comments, by all means.
Well, first of all, I offer my apologies because at this very moment, of course, they're doing some kind of landscaping right outside my office window. So it's going to be loud. I apologize. I'm trying to use a headset to help. I think, Your Honor, as is true in a lot of things in life, the answer about this is somewhere in the middle. I think we have two parties who adore their child and are legitimately interested in doing the best thing for her. I believe entirely that Mr. Wishart is doing the things that he can do under the idea that I'm not convinced that he believes he has a problem that needs to be addressed. I believe that he's doing what he can do to receive the treatment that has been recommended to him. In this particular case, I found that the most important thing to do was to rely on the professional experts that have become involved, who were Olivia Lovely and now the tribal health treatment plan. I think that to ignore those recommendations may leave room for Mr. Wishart to fall back on habits that have not necessarily been healthy for him or for his family. My particular concern around Ms. Lovely's recommendation is that in my conversations with Ms. Wishart, she expressed very serious and very concerning experiences with Mr. Wishart in their relationship. And I share the concern that those things can impact a person as a parent, those kinds of behaviors, those kinds of reactions. It's important to me that as the person who got to engage with these people on all these levels, that those recommendations be taken as seriously as possible. I do not believe that Mr. Wishart is a direct threat to his child, but I do believe he needs a lot of help with anger management and with knowing how to deal with extraordinary emotion that comes out at him unexpectedly and where that goes. And like I said, these are recommendations that are coming from professionals that I believe have a clear understanding of who these people are. I'm also struck that given all of Mr. Wishart's attempts, and while it is true we've had a relapse and dishonesty along the way, I don't deny that. I am struck that with the number of negative tests we have, that there's very little acknowledgement of that from the other party. A constant lack of belief that he's doing these things and demanding more evidence and more evidence and more evidence. And again, I understand the lack of trust given their marital history and given the level of dishonesty. But I think to discredit the amount of work that is being done towards trying to improve is disappointing. Other than that, I stand on my report, and I would recommend that we listen to the experts who got involved with this case.
I appreciate that. I do have one follow-up question. Do you know, were you contacted at all by anyone regarding the Cowlitz tribal evaluation for Mr. Wishart?
No, Your Honor, and in fact, I received that documentation at the same time that everybody else did. I have not had contact with anybody there.
Okay. Ms. McLean, any questions for Ms. Kale?
No.
Ms. Baldwin?
No, Your Honor.
Okay, thank you very much. Ms. McLean, any other comments?
The only thing that I would come back with is if you go to Olivia Lovely's evaluation, she is recommending that he participate in a domestic violence intervention with Washington State Certified Program. And I misspoke. It is 26 weekly groups, individual sessions for 6 months. My client is attempting to see if the tribe could accommodate that, perhaps at a lesser expense. I'm still waiting to hear back from that. But here's the bottom or the last sentence of her recommendation on page, I think this is, page 1. This program is recommended for individuals who have met the criteria for a level 1 program, which is considered a low risk program. It's a low risk program. And that's because when you read through her evaluation, she specifically found, and this is in this paragraph above that, the information obtained through this evaluation indicate that Mr. Wishart is not a primary aggressor, but counsel wants to hang a DV tag on him. Obviously, individuals can always benefit by additional classes, by, kids don't come with manuals. Behavioral interchanges with other individuals don't come with manuals. So everybody can always gain by having some more tools in their toolbox through outside education. The same could be said of Ms. Wishart, because she was the other partner that was involved in this. So is Ms. Wishart that primary aggressor? Ms. Lovely, who evaluated Mr. Wishart, found specifically that he is not a primary aggressor. So he does not qualify for that DV tag, and she has not recommended domestic violence treatment. She's recommended an intervention program, which is for a low-risk individual. The other thing is, counsel argued that my client has no expenses. My client is paying her vehicle payment, his vehicle payment, their joint automobile insurances, the family health insurances. He's paid the attorney's fees that this court has ordered to her. He's paid copious amounts of spousal maintenance on a short-term marriage. He is covering treatment expenses, UA expenses, his own attorney's fees, guardian ad litem fees. To suggest that my client has a money tree in the backyard is complete fiction. My client is struggling financially. And the more we load on him, and if he's not able to meet those financial components that go with whatever we load on him, we're potentially setting him up for failure. I totally agree with Ms. Kale. Opposing side completely has blinders on as it relates to the good things that he's doing. And I think that that's part and parcel with her attitude coming into this, that she does not want this child to have a relationship with her father. And she withheld this child for a protracted period of time. So we're asking the court to move this forward and provide for the visitation schedule that we've asked.
Right. Anything further, Ms. Baldwin?
Only in the sense of Ms. Love's report. Ms. Lovely is a domestic violence it's a domestic violence evaluation that recommends 26 weeks, 6 months of treatment. That is domestic violence treatment. That's the reality of it. I think you can't parse around that as much as we may try to wordsmith it that way. And my client does acknowledge the things that he's done. And that's why she says, yeah, guardian ad litem's right as to phase 1 and phase 2. Let's move along. That is my client's acknowledgement. I don't think my client should have to be in a position of sort of congratulating him. What she's saying is, yeah, you've done good work. You have work to do. And that's why we should move towards the guardian ad litem's recommendation. So again, my client isn't sort of saying, no, don't adopt any of this. Don't move forward. My client is saying, yeah, guardian ad litem's right. Let's move along. I think that she should, this sort of idea that she hasn't acknowledged, I don't think quite matches with her declaration that says that the guardian ad litem's right.
All right. I thank you, everyone. I appreciate everybody's comments. I appreciate the report is very thorough, covers a lot of issues, different concerns that everybody has. I've reviewed it a couple different times, and to be very frank, the notes that I made when I reviewed everything that was submitted were adopt phases 1 and 2 of GAL report, allow GAL and respondent to communicate with Cowlitz tribe to see if it changes anything with the recommendation, enter the support order. So those are the notes that I made for myself. I don't normally just share those outright, but that's kind of where I landed. I did review again Miss Lovely's report based on the comments in Mr. Wishart's submission, and after reviewing the GAL report, because I did recall what Ms. McLean pointed out, that that there was that he doesn't appear to be the primary aggressor. And that may very well be the case. I'm not going to assume that he's, I'm not going to assume anything, frankly. But what it does say is that their treatment is needed. So I think treatment is needed. Does it have to be the specific treatment through Miss Lovely? I don't think that it does. I think if there's other options for him to take, because to me, it appears to be kind of a anger management, domestic violence sort of hybrid situation that needs to be addressed. And so I do think that that is appropriate. I am going to ask that there be an ROI for Cowlitz Tribe to the GAL and Miss Wishart for any collateral input, because we are on his third evaluation at this point. All of these evaluations should have been with collateral contact. And frankly, I don't recall if the second one at Kaiser was, and it doesn't matter anymore because he moved on from there. So there is a little bit of concern that the court has, and I could be completely off base, but it does sort of hint at I'm shopping around to get an evaluation that works best with my schedule and what I think I want to do. If that's incorrect, then, please tell me I'm wrong. But at this point, I don't have anything to show otherwise. And now all of a sudden we've landed at an evaluation that is drastically truncated the type of treatment that is needed. And we have no indication that collateral contact was allowed for that. So I would like that to happen. And if it doesn't change anything, great. Then he's already working on his treatment. If it does change something, great, we'll deal with that. I do think that there are other programs for domestic violence. I know that there's online programs that are available. I had another case where someone did a 52-week online program. It was much more cost effective and frankly had a lot of really good information. We're not looking at a 52-week program here.
Do you know who that was with? Could you provide that information or tell me?
I can try to look for it.
Yeah,
it was,
okay.
I'm trying to think of the attorney who worked with their client to get that set up so I'll think about that. And if I remember, I'll email both the parties and Miss Kale. But it ended up being a program that was approved by the Washington State healthcare provider, like it was something that was an approved program through our state. And they were able to do it online and it was measured. So it wasn't like you could go on and do 52 weeks of sessions in a month. It was, I think you could maybe get it done a little quicker than a full year, but it was still sort of a progressive thing. So I'll try to recall who exactly that was. And there was not I think it was a one-time cost and it wasn't substantial. So that may be a better option. And I'm assuming that they have other programs other than just a 52-week program. So I'm not super concerned that it has to be with Miss Lovely at $35 a pop. I think, if we can find some other program, even if it is virtual, that would be appropriate. So I will adopt 1 and 2, phases 1 and 2. I do want to indicate that as far as phase 2 goes, so there's the 1 4-hour visit for that week, and that would be essentially the start of unsupervised visits, and the 1 overnight that would be on the first day and end on the second day. What I'd like to look at is making that a 2 overnight. So with the change that phase 2, you get a 1 4-hour visit and 1 2 overnight visit. All the other requirements, so maintaining UA, testing, demonstrating sobriety as far as any UAs that are requested or any concerns, all that would remain in place.
Can we provide for some holiday time?
I do see that there was some suggested holiday schedules outlined in the GAL So, you know, Father's Day with dad, Mother's Day with mom, and then suggested timeframes. It says Thanksgiving with dad, even, mom, odd, Christmas Eve, mom, even, dad, odd, Christmas Day, even, odd. I don't know if
So
there's
my recommendation is what I do when somebody's on a phased plan is basically say you adopt sort of the garden items broad strokes, and then Mr. gets a time period that's equal to whatever his phased program is. So if he's currently at 4 hours, he gets a 4-hour visit. If it's his year for Thanksgiving, if he's at an overnight, he gets an overnight, you know, whatever it is, it just sort of matches on an even odd sort of alternating basis is the garden item recommended.
So what is the visitation for the phase 1?
So phase 1 is my understanding is phase 1 is basically to continue what the current status is. And I guess Garden Lab can confirm.
That was
Yeah,
my
I mean,
understanding.
it doesn't, so what are we at, a 6-hour visit, 4-hour visit?
I thought we were at 6-hour visits at
I think
this
we're
point.
at 6. I can
Okay.
confirm.
they're 6-hour supervised by family.
That's correct.
All right.
So because Thanksgiving is right around the corner, and I don't know, I guess, Ms. McLean, do you know that your client's work
don't know.
schedule for Thanksgiving?
I don't know that.
And we can try to work some of those details out. If Ms. McLean, if you want to rush the order and if your honor has time on this Friday, because I know we're super time limited before Thanksgiving. And I'm unfortunately not available next week. So if you want to do it that way, or we could even do it via email if you want to get his work schedule and we can discuss.
So when do we want to do presentation?
If you want
I have the
go ahead.
10th, the 14th, or the 28th are the next available dates for me. The 21st, I'm not here, and that's 2 days before Thanksgiving. I don't know if you want to sort it out prior to that.
So the
I
14th?
have a funeral on the 14th, unfortunately. I can do the 10th or the 17th.
The 10th is a holiday, we're closed.
Oh, right. 17th?
I'm not here on the 7th.
Recognized Veterans Day on the 10th?
Veterans Day is the 10th, yes. So this Friday isn't
Okay.
available. I noted, I said the 10th, but unfortunately, yes, we're not
Okay.
open
And
on
I'm
the
sorry, are you available the 17th?
No. We can, let me, if you want to hold one moment, I can see if we can find a special set time for next week that's not the 14th. We have Monday, the 13th at 1 p.m. for half an hour available. Does that work for everybody?
The 13th at 1.
That works for me.
That is Monday, right? Yes, Monday, the 13th at 1 o'clock. Okay. Perfect. Thank you very much. Thank you. Bye-bye.
Thank you.
All right. So Monday, the 13th at 1 p.m. for presentation.
All right.
And that'll be there'll be as I'm assuming a Zoom link created, and that'll just be a special set. I just spoke with Miss Paul, and she's going to contact the clerk's office to ensure we can have a clerk available, and barring any issues, 13th at 1 p.m. for presentation.
Okay, thank you.
And then so I would just ask that because so much of schedule phase 2 is associated with his calendaring, that he have to provide for my client with a work
I've got
schedule.
them coming, council.
Okay, great.
I've got them coming through January. I'm just can't put my fingers on them right this minute, but I'll get them to you for presentation.
Perfect. And then I think, and then I would just ask to make it clear that the domestic violence treatment is either through the outfit that the court referenced whenever we can get that information, if we can find it, or through another Washington State certified provider. I agree it shouldn't have to be through Miss Lovely, but I do think sort of apples to apples, it should be a Washington State certified person.
I will, it may have been Miss Winkle's client, but I could be wrong about that, but I will work on that, and hopefully we can have some leeway in the order that it doesn't hold up anything, because I don't, if we can progress to phase 2 sooner than later, I think that's probably best for everybody.
Thank you.
All right, thank you.
Thank you.